Case 1070, West Oates versus Porter. All parties, please step forward.
LaShavia West is suing videographer Chad Porter for the production costs of a music video she never received.
You are Miss?
I'm LaShavia West.
You have a band?
No, I'm a music artist, and I also put on events. He's a promoter, and we do a lot of events together.
Did the both of you hire the defendant to do a video?
Yes, ma'am.
Yes.
When?
We actually first paid him March 29th.
Of this year?
Oh, I'm sorry, March 29th, 2021. Yes, ma'am.
And when was he to produce the video?
2 weeks after it was videoed, April 11th.
Okay.
And I have evidence of it.
Okay. And when did he get the video to you?
I never received it to this date.
How much did you pay him?
We paid him $1,500.
You have a claim against him for $10,000.
Yes, ma'am.
Yes, ma'am.
How much was the total price that you were supposed to pay him?
Was $1,500 for him to film and shoot.
But he did film and shoot.
Yes, ma'am.
Is what you're telling me that you never received a video from him?
No, ma'am.
Is that correct?
No, ma'am.
Tell me when they got the video.
We sent her a rough draft.
When?
I think it was March
May.
28th.
No,
Just
it
don't
was May
speak.
28th.
Don't speak.
May 28th.
May 28th. It was May 28th. We sent her a rough draft, and I explained to her it was a rough draft and that it was more that needed to be done to it, and it's not the final copy.
Did you ever make a final copy?
Yes, I have one, and it's here.
Okay. Did you ever give it to them?
No, ma'am, because she said that she was suing me, so I said, let's take this to court then.
But you have a final one.
Yes, ma'am.
I actually have a clip of the full, what was supposed to be the full preview that I received a month and a half later.
Listen to me. I asked you a question. I said, did you receive anything? You said no.
No, I didn't receive the video. That wasn't the video.
What
that
did
was
you-
that was what they call the full preview, but it wasn't a full preview.
So you did, in fact, receive something from them.
After, a month and a half later.
I don't care whether it was a month and a half later. You have a written contract with them?
No, we have our invoice.
Do you have a signed written contract with them?
No.
Does the invoice specify anything other than the price and say video footage?
Yes.
May I see it?
We also hired him for other
Just a-
behind-the-scene events.
Just a second.
Yes, ma'am.
Well, the whole price was $17.50. That includes the recap video. I don't know what that means, and I don't
That
care.
was other footage. We have also hired him for other event footage that we had other
Okay.
events.
Okay, so the whole thing together was $1,750 or
$1,500, ma'am.
$1,500, and you gave them the $1,500.
Yes,
That
we
was
did.
just a video.
You acknowledge that? Okay. Would you take a look at this and just show me where it says it has to be delivered by a certain date?
Oh, I have a...
Just a second.
Yes, ma'am.
Just show me that invoice and tell me where on that invoice it says it has to be delivered by a certain...
Nowhere on the invoice, ma'am.
It does not? Okay. So it does not. But that was the document that was created at the time.
Yes, his manager gave to me after we paid.
Doesn't matter. That's what you accepted without anything else. That was the agreement. He was going to produce this video. Now, if you then say to him in a subsequent text, I need it by, and he agrees to it by, if we're going to modify that agreement, which was the invoice to produce a video, which he says that he has, and you say that you modified that agreement that he agreed to, I will look at that, and if you have it in a text message, I'll look at it. Can I see it?
Yes, ma'am. This is from his manager, Angie.
Who's Angie?
LaShavia West claims videographer Chad Porter did not deliver the music video she paid for. Chad is countersuing for defamation of character.
Okay, so they sent you a preview of the video, full preview, and you wrote back, I hate it. Is that right?
Yes, they sent the preview.
Just a second.
Yes, ma'am.
And that was in May.
Yes, ma'am.
That was in May. Yes. When did you advise them that you had the completed video?
Well, we never got to that point because I sent her a rough draft and I told her that we were going to make the final copy. And she took advantage of the one time that I went on vacation, and I made it clear when I was going on vacation I was turning my phone off and not taking my computer. And, you know, I would think that she would call Angie if an emergency happened.
Well, I don't care what you think. When did you get her or notify her that you had the final cut of the video?
I didn't because once she told me she was going to take me to court, I stopped everything. And because she was defaming my name so much, and
Okay, so she never got a final cut of the video.
No, ma'am.
All right,
She
so she's
never did.
entitled to her money back, $1,500. That's one. Now, the second part of this case is for defamation. So that resolved your $10,000 claim. You get your money back from him. Tell me about the defamation.
Okay, so once I think it was...
Date that you're claiming she defamed you.
The date that she defamed me was June 16th, which was 2 days after I went on vacation and made it clear that I didn't have my phone.
Don't tell me what you made clear. June 16th. I'd like you to show me what she said to defame you.
Okay. Okay, it's tons of stuff when she was defaming me, but
Okay.
okay.
All right.
Okay. Well, it's clear that she's angry that she didn't get the video in time.
Excuse me.
And she didn't.
We never set an exact time.
Well, actually, somebody who works for you did.
Okay.
Because somebody, looks like April 29th.
Yes, ma'am.
Also, your video will be ready this week coming. You'll get a preview in a couple of days. Was that what you wrote to her?
Yes.
Yes. That's all. That's your agent. It's the same thing. So your agent suggested to her that...
Was she suggesting the draft, though?
The draft.
Yeah,
right.
she said, I'm just reading what I said here.
Yes.
Also, your video will be ready this week coming.
Yeah.
You'll get a preview in a couple of days. That's what it says.
Okay.
That didn't come to pass.
Okay.
Okay? And she's complaining about that. I mean, that was the end of April. Now we're talking about June 16th. There is a certain, I would assume, time frame in which you need one of these things in order to do with it what you wanted to do with it for publicity. So I don't see anything here that's purposefully defamatory. She paid you, or they paid you the money, the $1,500. They didn't get delivery on time. Right. It's irrelevant to me whether you go on vacation and turn your phone off and turn off your computer and turn off anything else. She was angry that she didn't get what was promised to her by your company. So your countersuit is dismissed. On the
May I
plaintiffs.
say one thing, though?
Yes, of course.
The thing is that, you know, by her telling everybody that I robbed her and I stole from her and that I'm a thief, that's not true. I sent her a copy, and...
No, you didn't send her a copy when it was due. You didn't. You turned off your phone, you turned off your computer, and she didn't get anything for a month. So she didn't get anything for a month. Your agent said to her, you will get the video next week. That didn't happen. The fact that you went away on vacation is not relevant. Your counterclaim is dismissed. You own their $1,500 back. That's my judgment. Thank you very much.
Court is adjourned.
No, we're finished.
Okay.
Excuse me, Judge Judy. The damages and losses for the $10,000 that we
$1,500. That's my judgment.
I receive it.
Good.
Thank
You
you.
don't get the video, though.
I'm fine. I didn't want to use it
Good.
anymore.
This way, sir.
I love your show.
Great.
And
Me
you
too.
too.
Whatever the judge says is what I deserve.
I love Judge Judy, so I'm going to rock with you on that, Judy, because I got my money back.
I just really want to see her make it. Since she's in her 40s now, so.
I'm not the only person. He's done it to other artists in Houston as well.
She's known for scamming people, and it didn't work this time.
I still took a major, major loss.
$1,500 for a video, that's no problem. I don't mind that. She can have that.
His work just wasn't up to quality, and it wasn't for us, and it was a very horrible, horrible experience for me.
She hasn't even seen the final. The final looks so much better. The final looks fire.
It was horrible. It looked like it was Snapchat.
I'm glad that she said she can't have the video. I'm not blessing her with my skills.
I always have a delivery day and deliver, because he doesn't deliver, and many people know that he doesn't deliver.
I know that you and I may disagree on this point. The invoice is not really a contract, but this invoice had exactly what they were going to shoot, when they were going to shoot it, the amount of money that was paid. And in reliance on that invoice, plaintiff paid $1,500. The defendant, in reliance on the invoice, actually shot the video. The only thing that was missing in that invoice was the date of delivery. And if time was of the essence, that had to be in the contract.
I mean, it's always smart, especially if you're going to rely on a certain date. I think that's where we might have some disagreement, is I think that the plaintiffs detrimentally relied on that invoice. She booked event space for a listening party or viewing party that was never able to take place due to not receiving the video. So I think she also had a couple claims for getting paid back if she had already paid venues.
You mean damages other than the amount of money that she said? And I would agree with you if the invoice had a date of delivery.
I think people far too often think that an invoice is a contract. When you come to a legal forum, that's not the case. And I think that to have both and to especially have dates on it, if that's important to you, and time is of the essence, I think that's the best lesson.
All parties, please come forward.
Ayanna Kennedy is suing her ex-boyfriend, Brandon McKinney, for damages caused by a fire.
All right, let me see if I understand this. Miss Kennedy, this used to be your boyfriend.
Correct.
A couple of years ago, you shared an apartment together.
Correct.
Where?
St. Louis, Missouri.
Well, when did you sign the lease on the apartment?
I signed the lease January of 2020.
Who was on the lease?
Just me, Ayanna Kennedy.
Do you have a copy of that lease?
Yes, I do.
I'd like to take a look at it.
How you doing? Yes, ma'am.
Okay. When did Mr. McKinney move in with you?
He moved in two months after.
So in March
Yes.
of 2021.
Yes.
And he was your boyfriend.
Yes.
And he lived there for how long?
I'll say like 4 or 5 months maximum.
When did he move out?
He moved out and I put him out. He put him out like around late, was it September? Early September. It was early September when I put him out.
September of?
September of, I can't really remember. It was late August, early September. It was like, okay, because I left out of town at the 5th, so probably like around the 1st. It was really.
Listen to me.
Around the time.
Stop talking to yourself out loud. I asked you a question. The question was, when did he no longer live with you?
Ayanna Kennedy claims her ex-boyfriend, Brandon McKinney, owes for damages after starting a fire in her apartment.
Listen to me. I asked you a question. The question was, when did he no longer live with you? That's a month, a day, and a year. Think to yourself. Don't think out loud. You signed the lease January 2020. It was a 12-month lease.
I put him out September 2020.
There was a fire in your apartment. That's what this case is about. In October of 2020. And the fire was in your house when the defendant was there. He was there with your permission.
Correct.
So far, correct?
Correct.
And there was a fire there that destroyed part of the residence and furniture and other personality.
Correct.
Which rendered the apartment uninhabitable. You couldn't live there.
Right.
According to the terms of your lease, the landlord was supposed to provide you, when you couldn't live there, with a like premises in the same complex. Did the landlord provide you with a like residence in the same complex?
No.
Okay. Then the landlord terminated this lease. It's in here. It says if the apartment is destroyed by fire, the landlord has 2 options. Fire, amongst other things. He can find a like premises for you until the apartment is finished, or you can terminate the lease. You chose to terminate the lease?
No, I didn't.
Well, did you live in the apartment?
I did live. I asked him, can you give me another unit? He said he don't know about that.
Well, just a minute. So in October of 2020, did you live in the apartment after the fire?
No.
Where did you live?
I went home with my mother.
Okay. Did you pay rent in October?
I did.
Did you pay rent in November?
Yes, I had finished out my lease.
You finished out your lease by paying your rent and didn't live there. Show me. Show me that you paid your rent.
Well, I don't have that here.
Well, that's what you're here for. That's what you're here for. There was a fire in the apartment. You're not a fire marshal, are you? No. Okay. So you're here because they kept your security on your apartment, but your lease specifically provides that either the lease will terminate or the landlord has to find you another apartment. And you say you paid rent even though you were living with your mother, which I don't believe. So had not lived there. So you want your security deposit back from him. They kept your security deposit, and you claim that he was the reason for the fire.
Which is true.
Well, I don't know if that's true, and you can't prove that's true. You were out of town. He says it was a faulty electrical wire.
He was responsible for the fire. It's in the report. They said someone left the eyelet on the stove. He was the only one there. The stove didn't come on by itself.
I don't know.
He was there. He admitted to it. He said he was cooking something and he ran out the house and forgot the stove was on.
And?
The whole apartment was burnt up to a crisp.
And?
The landlord knows that he did it.
I don't know what the landlord does. I don't even know if he wasn't living there. He says after this whole thing happened, he took an apartment. You were supposed to move in with him. Is that right? Is that what you said?
Yes, ma'am.
And where was that apartment that she was supposed to move into?
My apartment that I live currently.
Do you remember when she came home after the fire?
Yes, ma'am.
Did you see her after she came home?
Yes, ma'am.
After the fire?
Yes.
Okay. Where did you see her?
At the apartment.
At the apartment?
Yes, ma'am.
Were you able to live in the apartment?
I actually stayed there.
You were staying there after the fire?
Yes, ma'am. Where?
Just.
Yes, ma'am.
Just answer my questions.
Yes, ma'am.
Great. So there was a fire. There was a lot of damage. But you slept there.
Yes, ma'am.
Did you sleep there for more than one night?
Yes, ma'am.
How long did you sleep there?
I slept there about a week.
When did she come home?
The end of that week.
Okay. What happened when she came home?
When she came home, she began to examine for damages, and of course, her family came over. They proceeded to repair the damages. Like she had couches, clothes and things of that nature. So they took those out and got those refurbished.
And?
And then after that, she moved in with her parents. I moved in with my child's mother.
So you never stayed in the apartment with her together?
Not after October.
Not after October?
No, ma'am.
So what was this baloney that you wrote here in your answer that you took an apartment that she was supposed to move in with you?
That's now.
Oh, that's now?
Yes, ma'am. October, when the fire happened, she went to her mother's house. I went to my child's mother's house.
See, I have nowhere to stay.
Okay, and then what happened with your child's mother?
My child's mother, me and her, we ended up falling out. So I ended up living with my grandmother while she was still living with her parents.
And then?
Then I proceeded to get an apartment for us to not have to.
So let me ask you this question, Mr. McKinney. Since the fire, have you had, since the fire,
yes,
since you were supposed to get an apartment together, recently,
right,
I assume that you got back together at some point?
Friends, cordial, of course, a little more than cordial.
Well, you know, I'm cordial with the guy who seats me at my table,
right,
number 35 at the restaurant.
Right.
I'm cordial, I say. How are you? Beautiful day today. There's no smog here. It's lovely to be out. When you say a little more than cordial, Mr. McKinney, you have to be a lot more than cordial to think about taking an apartment together.
For sure.
For sure.
Yes, ma'am.
Now, my question is, were you a little more cordial with Miss Kennedy at your grandmother's house or at her parents' house?
At my grandmother's house, for sure.
Oh, for sure.
I apologize.
Was your grandmother home? Yeah.
Yes, ma'am.
Could you stand up for a moment, please?
Yes.
Thank you. Your last name is?
Lee.
Miss Lee.
Yes.
Grandson?
Yes.
You like him?
Love him.
Oh, he's cute. He's cute. Oh, he's cute. Did you ever see Miss Kennedy in your house within the last year?
Yes.
How often?
Not that often, but yeah, she came and visited.
She came to visit who?
My grandson.
Did she ever stay over?
Yes.
Your case is dismissed, Miss Kennedy. We're finished. Thank you very much.
Court is adjourned.
The judge is dead wrong.
By the time I came back, it was just flames, you know?
He burned down my apartment. I was gone out of town.
No, I never promised her anything.
The universe is going to get him.
I am for sure that I've never been slightly more than cordial with anyone in your house, and I've lived with you on and off for years. So I found that very funny.
It was funny, and I believe you.
Yeah, and I think that grandmother was a sweet soul, and she loves him because it's her grandson, but you know, that line has got to be somewhere. He'll find it.
Jennifer Perry is suing her former friend and wedding coordinator, Carla Williams, for a refund for wedding planning services and the cost of decorations.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 1104, Perry versus Williams.
Thank you.
You're welcome.
Miss Perry, you hired the defendant as a wedding planner for your daughter's wedding.
That's correct.
You had known her before.
We used to be coworkers about 20 years ago. We did have a friendship outside of work. Yes.
Tell me when your daughter's wedding was scheduled.
June 12th of 2021.
So it took place?
It did.
That's your daughter?
No, she wasn't able to travel today.
Okay. In what month did you hire the defendant?
November 29th of 2020.
Did you have a written contract?
We did not.
Is there any reason why you did not have a written contract? This is your business.
That's correct.
And according to you, you've been in this business for a long time.
That's correct.
Do you have a contract with other clients?
Yes, ma'am.
And is there any reason why you didn't have a contract with the plaintiff?
I did. Well, because Jennifer and I are, we were good friends, and I just took her word. So, and that's what
That's
we
a
went.
bad idea, Ms. Williams, because this is business.
Yeah, exactly.
And if this is your business, you're supposed to have a contract.
Correct.
And you're supposed to have a contract. You signed a venue for your daughter's wedding?
Correct.
Did you have a contract?
Yes, ma'am.
Did you have a caterer for your daughter's wedding?
I believe so. My daughter coordinated that with her father, but I believe so.
So her father paid for the caterer?
Correct.
I have to assume there was a contract, unless your
I would
father
assume
does
so as well.
cooking.
I think you're correct.
What did you pay for?
I paid for Carla's services.
Just a second. Okay, what else?
I paid for the decorations.
What else?
I helped with the bachelorette party.
That I don't care about. I want to know,
Carla's
Ms.
services.
Perry,
Yes.
exactly what did you pay for?
I paid
You
11
paid for the decorations.
Correct.
Which were, according to what I read, maybe a couple of $100.
What I paid for through Carla, yes.
Was a
ma'am.
couple of $100.
But
And the defendant's services were $1,100.
yes, ma'am.
How many people were at the wedding?
Close to 100.
Was there a dinner
There was.
at a venue?
Yes.
With music,
DJ.
DJ, cake,
Yes.
So your contribution to this was $1,100. I'm just setting it clearly. And you were supposed to provide the wedding planner who would do the arrangement for flowers, who would arrange for a DJ. Okay, so it is your claim that while you paid her $1,100, which I don't think you deny, that she paid you $1,100,
Correct.
prior to the wedding, you claim she quit. The defendant says that you fired her.
That's not true.
That's what I'm here to find out. The total cost that Ms. Williams quoted you for her services was how much?
The number changed.
Just how much was the last number she quoted you for the job?
$1,100.
No, that's wrong. That's not true. Be careful what you say, because at this point, we're not in a good place. She said she quoted you $3,882.
That was never provided to me. Never have I seen that number. This is the
That's
first
not
time
true.
I'm hearing of that number.
Okay,
That's not true.
very good. So you tell me the number that she quoted you to do the entire job.
The entire job was $750, and then it was going to be an additional $100 to rent a love table that she had. As we proceeded on, she tacked on an additional $230 to cover the rental of additional items that my daughter wanted to use. Collectively, we came up at $1,100, to which she has been paid fully.
Now, in going over what she was going to do, one of the things that she was going to do was to hire a DJ that I assume the bride's father was going to pay for. Or were you supposed to pay for the... Just very careful what you say to me, because right now, Miss Perry, you're doing that lilt from foot to foot, which makes me a little uncomfortable.
Okay, sorry.
Do you understand?
Yes.
No, it's an uncomfortable thing because you're trying to get where I'm going, which is not an easy place to get to, because I have 5 children, all of whom have been married at least once and planned weddings and know what wedding planners do and know what their function is. So I've had experience.
Understood.
And the country is pretty much the same. Ms. Williams' problem is she runs a business and she didn't do a contract, a written one.
Can I speak?
So what I asked you was very simply, as part of your arrangement with your ex-husband, who was paying for the wedding.
He was paying for some of...
He was paying for the vast majority of the wedding.
That's not true.
According to you, because he was paying for 100 people for food.
I said for the caterer, correct.
He paid for the food.
The caterer.
He paid for the venue.
No, the venue was paid for by the groom's parents.
Okay, so the groom's parents paid for the venue.
Mm-hmm.
Your ex-husband paid for the food for 100 people.
Okay.
And you're telling me that your total responsibility so far was the $1,100 that you paid to the defendant. And my question to you was, my question to you was, as part of your responsibility with the wedding planner, she was going to acquire a DJ.
Which would need to be approved.
Just listen. My question is, who was supposed to pay for the DJ?
That discussion did not take place.
I'm not believing you at all. I'm not believing. Why? Why is that? Because this whole case revolves. Put your hand down. This whole case revolves around the DJ and a problem.
That's correct.
Don't tell me I'm correct. I'm always correct, except when she says I'm not correct.
Perry claims her former friend and wedding coordinator, Carla Williams, owes for a refund for wedding planning services. Carla is countersuing for breach of contract, lost wages, and defamation of character.
Okay, so if you were supposed to pay for the DJ as part of your responsibility for this wedding, as part of the wedding planning thing, and what happened here is that the groom's aunt, they said, we could get the DJ for free, so we're not going to use her DJ.
And I'm sorry.
That puts me in one category of my head. If you were supposed to pay for the DJ, and clearly somebody is supposed to pay for the DJ, because this wedding was pretty well planned out, Miss Perry. The groom's family was paying for the venue. The bride's father was paying for the caterer.
Yes, ma'am.
You were supposed to pay for certain decorations and wedding planning. In that package, were you also supposed to pay for the DJ, is the question.
We were sharing responsibilities for finance, so it wasn't agreed upon. They didn't come to me and say, here's the DJ.
I asked you who was supposed to pay for it.
It would have been, I would have been happy to pay for the DJ if that's
fine.
who she
Very
was
good.
selected.
Then I'm going to deal with this case. I'm going to deal with this case on a very simple basis. I'm going to deal with it since you have no written contract on a quantum merit basis. On what month were you hired? Month and year?
November the 29th, 2020.
When, according to you, you told your services were no longer necessary?
The day of rehearsal, she told me my service was no longer
Yes.
available.
Just a second.
May 18th, 2021.
Can we agree on a date either of being fired or quitting on May 18th, 2021?
Yes, we can.
Great. Between November 29th, 2020, December, January, February, March, April, and half of May, 5.5 months, tell me what you actually did in furtherance of the arrangement that you had with the plaintiff.
I prepared piping draping, which they ordered 2 piping drapings for the bride. I have pictures that can
I'd
show
like
you.
to see it.
In your honor, she did
Great.
not ask the
Don't-
bride.
Just a
what-
second. Just a second. Don't speak. I am now ruling on this case based upon how much time and what she actually did during that 5.5 month period
Understood.
to absorb $1,100. And if you fix a reasonable hourly to her expertise, I'm going to figure out whether or not she is entitled to keep, because I think that the arrangement you had with her was to pay substantially more than $1,100. But since she doesn't have that in writing anywhere, if she did any work, you don't get your money back. You understand that?
That's not what she stated to me.
Just a second. I don't care what she stated to you. That's why you're here in court today.
Understood. Agreed.
Very good. So you're here in court today to determine the worth of her work for 5.5 months and whether or not she used up that $1,100 in work that she did for you. Okay. May I see it, please? Okay. Was this done specifically for her wedding?
Her daughter's wedding. Yes, ma'am.
Okay. Did you send her pictures of this?
She saw that picture in your hand.
Did you discuss what they wanted, either with her or with her daughter, about what color she wanted? Did you have those conversations?
Yes, ma'am. Yes, I did.
Are these the flower arrangements that you did for the wedding?
Yes, ma'am.
Are these her daughter's color?
Yes, ma'am.
Did you send her these pictures?
Yes, she saw pictures. She even saw it in person.
Tell me when she saw them personally.
It was in November when we met up. It was also in December because I met up with him several times.
How many times did you meet with them in December?
It was maybe 2 or 3 times.
Where?
At my home.
Who was present?
Jennifer and her daughter.
Were these made up of fresh flowers?
No, those were not. Those were silk flowers for the wedding.
Silk flowers that you own, that you arranged in order to show her and her daughter?
That's correct.
Okay. Who told you what the colors were, blue and white?
Jennifer and Alexa, her daughter.
Okay. So what you do is you take the color scheme of the bride.
That's correct.
And create this.
That's correct.
So these blues were bought just for this wedding?
That's right.
Okay. How much money did they cost?
With that big bundle there, that was about $400 because silk flowers are very expensive.
Who paid for those?
I did.
Did the plaintiff reimburse you for those?
No, ma'am. They belong to me.
But these were purchased in this box for her wedding.
That's correct.
Ma'am, that's not true. I actually had provided Carla with the flowers that I had purchased for Alexa's wedding. That is not for Alexa's event exclusively.
The flowers that Jennifer bought for her daughter, you know those the flowers, they're wooden, they on the skinny stem, and
Don't speak.
And they're very, very small. They're wood. Those are the flowers that Jennifer provided. And when I saw those flowers, I said, Jennifer, these are not going to work. If we're going to use these flowers, we're going to have to add some of the flowers I have, because if we want it to look full, those little flowers are not going to look appropriate.
Did you return those to the plaintiff, the ones that she brought?
Yes, she picked those up. Yes, ma'am.
Okay. Yeah. Careful with me. Very careful. Did you give to the defendant a certain number of flowers that you purchased?
Yes, ma'am.
Did she return them to you?
Yes, ma'am.
You didn't purchase any of these flowers.
That's correct. That is not.
Don't speak. The answer is no.
No.
Next question. Who did the flowers for your daughter's wedding?
I did.
Personally?
Personally.
So you did the arrangements for your daughter's wedding?
Yes, ma'am.
I'd like to see a picture of it.
Okay.
Of the flower arrangements.
Okay.
If it makes a difference for your judgment for how much she gets paid by the hour, I know her complaint says that she's been working for 12 years. The LLC was incorporated in 2018. Mm-hmm. So she must have had some sort of business prior to this design company.
I found a photo of Alexa's bouquet.
I'd like to take a look at both.
Sure.
Now, I'm not talking about your daughter's flowers. I'm talking about the flowers for the table.
Oh, I'm sorry. We were discussing bouquets.
No, we weren't discussing bouquets. Did I ever use the word bouquet?
No.
I never used the word bouquet.
Here you go. Sorry.
Okay, so on the head table, You had a nice something of flowers, reasonable, and then you went for the tables. You went on the cheap side.
No, that is what my
Sure.
that is
Oh,
what
sure
my
you did.
daughter wanted.
Sure you did. You went on the cheap side. Okay, I got it now.
Those are the items that my daughter had picked out. That was the
Okay.
display that she wanted.
Fine.
The
Very
expectation
fine.
of the wedding
Very, very
coordinator.
Good. Very, very good. Listen, I want to explain something to you. I got this whole thing. I got the whole thing. She spent time putting together items, meeting with you. She met with you and your daughter. I would guesstimate at least 4 times, probably more.
It was more than that.
No,
Probably-
it was 3. 3 maximum.
No, that's not true.
That is true.
Did she come to the venue?
Yes.
She came to the
Is
venue
that
on
just a second? Just
February
a second.
23rd.
Is that the 4th time?
No.
You're telling me that you met with her twice? Just a second. You see, let me tell you why I don't believe you, because other than the fact that you're getting red. Let me tell you why, because she met with you once on the 29th.
No.
And then what you're telling me is she met with you once between November and the time she went to the venue when she had this kerfuffle with a DJ who was the aunt of the bridegroom. So if that's what you're telling me, I'm telling you, I don't believe it.
Jennifer Perry has accused wedding coordinator Carla Williams of canceling her services 3 weeks before the wedding. Carla claims Jennifer breached their contract and defamed her.
Okay, so now you want to sit back and think about how many times you met with Miss Williams on this event after you first met with her on November 29th, 2020.
There was no meeting on November 29th, 2020.
I
sent her
said,
a
how
text
many
message.
times did you meet with her after November 29th, 2020? Think about it.
2.
How many times did you meet with the plaintiff after November 29th, 2020?
It was about 8 to 10 times we met. And because we met at the venue 3 times.
Okay, you met at the venue 3 times. Do you remember when you went to the venue?
I don't remember the exact date, but I know we went out it was in February, because that was the first time I had to go look at the venue so that I can get an idea of what exactly that they wanted.
Okay, so that's 1.
We also met in March.
Where did you meet in March?
We met at the venue again.
Who was present?
Jennifer and her daughter Alexa. We also met in April.
Where?
Well, we was in the car together because we went over to Illinois. It was a company that was selling a lot of the supplies that the coordinators or banquet owners have. So I mentioned it to Jennifer that we can go over there and look at a couple items for the wedding. So we were all 3 in the car together in Jennifer's car.
Okay. And how long did you spend there?
We was there for about an hour.
You have any recollection of that, madam?
I do.
Okay. When else did you meet?
And then we also met at the rehearsal.
Okay. And she never came to your house, so she looked at these pictures She looked at these.
Jennifer been in my house several times. So
As friends.
Just don't speak, because what I'm telling you is, I don't believe your story that you met twice. Do you understand? I didn't believe it when you said it, and now I'm positive that you met more than twice. Okay. After the road trip was the only other time that you met at the rehearsal dinner that you met.
No, we met several times because Jennifer brought some items to my home that she wanted at her daughter's reception, which was items that she wanted to be put on the grass because the wedding ceremony was outside.
Okay. So how many times did she bring items to your home?
She came 4 times.
Does any of that sound familiar to you?
Yes.
Very good. Your claim is dismissed for
Ma'am,
your $1,100. Your claim is absolutely.
Well, I wasn't allowed to interrupt. I'd like to present my side of the case. She's saying hearsay. I have facts. On November 28th is the date that we went over to the venue. I actually told her about the sale. Provided it to her.
Just a second. I don't care. You have no case. I don't believe that you met with her twice. You may not consider it a meeting, but when you bring things over to her house and discuss with the event planner where you want
That was
these,
a friend meeting.
Don't try to talk over me, madam. You had a limited responsibility. You had someone who trusted you, who you were friendly with, who had no contract with you, and you paid her a de minimis amount of money. So I didn't believe that based upon all of this, that you only met with her, according to you, 2 times. Is that what she said?
Yes.
2 times. But then when we go back to it, you did, in fact, take her time. She went with, don't speak. She went with you. I don't care if you went with your daughter. It's your wedding.
She needed a ride.
Don't speak. I don't care who drove. She went with you in her capacity as a wedding planner to look at items for the venue. You may not consider that work, but that's work. That's what she does for a living. Do not speak. Just listen. So since I don't have a written contract, and since I don't believe that you met only twice, I am paying her by way of quantum merit because I believe that she met with you closer to 10 times, not 2.
Correct.
Not
I have
2.
evidence of the times that we met.
Just a second. I'm speaking. You don't remember a lot until your recollection is refreshed. Now we're
Wow.
going to get to the counterclaim.
Yes.
She's got a counterclaim. Don't move yourself. Just listen. Her counterclaim is money owed for breaching the agreement. Forget it. Next time, put it in writing.
Okay.
Lost wages and defamation. So what I'm going to hear is the defamation part of your case.
Correct.
If you want a contract, you're a business person, put it in writing. Do you understand?
Yes, ma'am.
Great. Now, let's hear about the defamation.
Okay. After Jennifer fired me, she went on.
After you no longer work together.
worked
I didn't get to.
yes.
I don't need to know whether you quit or whether she fired you as a result of
That
this. Because
actually matters.
whether you fire her or she quit, it doesn't make a difference.
She was
Don't
the one-
speak. I'm done with your case. Now I'm going to find out whether or not you defamed her. Now I would just like to see what it is that you claim she said about you publicly to defame you.
Yes.
Let me see it. She posted, never do business here. I've been friends with her, helped her with an event, helped to prepare a baby shower. That's just unfortunate, but I am bearing the financial loss with 3 weeks until the wedding. She posted that.
Yes.
It's not defamatory. Anything else?
She's also on Instagram telling people don't use my business. She's false.
She's allowed, just a second. She's allowed to do that. That's her opinion. Did she ever tell you in the initial conversation that she had, which is something that you put in your complaint, this is just a point of interest for me, did she ever tell you that she had when she called you in November of 2020, that she had a small budget because Alexis, that's her daughter's father, was not contributing to the wedding?
Yes.
Did you ever tell her that?
I did.
Why did you tell her that? That's not true.
It was true at the time.
You don't
I have one
you don't
daughter.
Have you don't have the case for defamation. I'm going to have to introduce you to the truth. It'll be a nice first meeting. Thank you very much. We're done here.
Court is adjourned.
Unfortunately, she lied, but she was more believable.
I was trying to be a good friend and give her a family discount.
She told me that she would just give me back my money.
I've been truthful with her. I've been, there to help her whatever way she needed, but this is what happens.
It's very upsetting to lose a friendship of over 20 years, but it happens.
It's a terrible situation because it could have went a better way, but, she chose it this way, so this is what happens.
That defendant seemed pretty professional, despite the fact that she didn't have a written contract in this instance for her business. But otherwise, she seemed to have all her ducks in a row. She had all her evidence laid out. She knew what she had done for the plaintiffs in their wedding.
You go back to, it's so much easier if you have a written contract. If you outline what your basic agreement is, especially the cost, and what is going to be part of that, you're protected. It really helps everybody. So if you take away anything from this is if you're in a business, whether it be friend, relative, neighbor, if you have something that has a cost involved to it, put it in writing. Anyway, it's a good case. Yeah. And you should keep that card in case you need her. She sounds like a very reasonable wedding plan.
I might.
And now, the conclusion. Quincy Shagog has accused his former friend with benefits, Regina Monaghan, of driving his truck without a license and totaling it. Regina claims he vandalized her house in retaliation.
Now, did you come to her house July 17th?
No, I did not.
Where were you on July 17th?
In Chicago.
Did you see him there?
I did not, but I have video footage.
I'd like to see it.
Video?
Sarah, you're going to have to help me look at this, darling, because I could never see these things on these things. Oh, I touched something. I got it. Yeah, thank you.
It says video 1. I also have still frames of the same video.
You want me to pause it at that point?
Yeah, I would like to see a face. See if you could find a face for me.
There's still frames of that video that I took.
Here's just frame by frame.
Could you turn your head around a little bit?
Which way?
So I can see the back of your hair. I'd like to see those, Kevin.
There's 2 videos, Your Honor, so the second incident, I'm not sure if you want to hear about it first.
Okay, so he came, according to you, alone on this video. Mm-hmm. Where did these pictures come from?
I got them from when I filed a police report. I was released the actual disc to the Minneapolis Public Housing, so I took still frames off of it and printed them. I had them printed out.
Can I see the second video, Sarah?
spray painting.
Uh-huh.
The second video is only him breaking the back window and tagging my house.
Spray painting it?
Yeah, and tagging my house.
There's something breaking a window, it looks like.
That's not me, Your Honor.
Don't speak. Now, on July 17th, you stated that you were in Chicago. Prove it.
What do you mean, prove it?
Prove it. Just what I said to you. Prove it. You know what she's accusing you of. She's accusing you of vandalizing her house on July 17th and again on August 19th.
Well, I was doing a Windy City smokeout in Chicago around the same time. I worked 2 weeks.
Okay. In what event? Sarah's going to look them up.
Chicago Windy City smokeout.
July 17th, 2021.
It was July 9th until July 11th, 2021.
Yeah, we set up and tear down.
But that's all right. July 9th to July 11th. We're talking about July 17th.
That's the event. We have to tear down.
I understand that.
Okay. So that took a long time.
So far we have July 9th to July 11th. Where were you on August 19th?
Probably still in Chicago.
Doing what?
Anything other than probably that.
Okay. So what you're telling me, Mr. Shigong, is the following, that in 2019 and 2020, you visited with your daughter every 2 weeks, according to you, in Minneapolis, twice a month.
Right.
But in July of 2021, you were at an event that takes you a week to break down, it takes you a week to set up. You want me to believe that you didn't go in July, different from 2019, different from 2020, but in July of 2021, you didn't go twice a month to see your daughter. Is that what you want me to believe?
My daughter was down in Florida at the time.
You didn't go to see your daughter?
No, I did not.
Who did you leave her with in Florida?
My sister. I had my daughter for the summer, but by me working, that's when I went down there to let her have with my sister so I can go to work.
Why didn't she stay with her mother so that you could go to work?
Because her mother has her 24 hours, 7 days a week already, and I don't get to see my daughter.
Why would you just take her to dump her with your sister?
Because it was only a 2-week project.
Yeah, you see, well, your problem, Mr. Shigong, if you tell the truth, you don't have to have a good memory.
I don't have
what was the
reason to
damage
lie
to your
to you.
house?
I had 2 TVs broken, a PlayStation 4. I've had a HP printer broken.
The only thing that I saw was him tagging your house and breaking the window.
In the first video, you can actually see him kick the door. And then
That's okay. I didn't see him coming out with anything, breaking anything. I didn't see him inside.
I have pictures of all the damage that was done.
I believe that there was damage. I just have to connect him to it.
It wasn't me.
I have police reports.
I don't believe you.
I don't have no
I have
reason.
But I don't believe you, but that doesn't mean she can prove it.
I have police reports.
I'd like to
You
take a
don't
look at a
believe me
police
the whole
report.
time. Like I'm sitting there lying to you for some reason. I ain't gotta lie to you, ma'am.
You lied to me when you say you didn't leave her with the keys.
Okay, you the judge.
I am. It's a very detailed narrative by the Minneapolis Police Department, what was on the footage.
And later today, defendant Regina Monaghan is countersuing Quincy Shigong, claiming he burglarized and vandalized her property. Quincy says he was not in the state at the time of the incident.
Now, the police outline what happened. It clearly shows the plaintiff, who they describe to a T, and who appears in the footage going in the house and coming out of the house. Now, you moved out of that apartment complex?
Yes.
So any damage that was done, but you moved. I'm not going to ask you. Well, there were a lot of things that were going on there that were not right. And he damaged some of your property.
Yes.
And you drove his car, right?
Yes.
And you weren't supposed to drive his car.
Yes.
Because you have no driver's license.
Yes.
So you're asking me for some help, right?
Yep.
Yep. And there isn't a question in my mind that you vandalized her house. So you want me to help you. Courts don't do that.
Why would you think that was me that did that?
Because I saw pictures. And I don't have to have proof beyond a reasonable doubt that you damaged her house, sir. I have to have more evidence than not that you vandalized her house and damaged her property. And based upon what I've heard from both of you, there's more evidence than not that I believe that you did it. If I were in a jury and it was a criminal case and I had to prove beyond a reasonable doubt that it was you, I don't know if I could do that. Fortunately for me, my quantum of proof here in small claims court is just more proof than not that you did it. So I don't help you. Likewise, you had absolutely no right to get behind the wheel of a car. And your description of the events of the 26th of June, how this accident happened and what you were doing, driving around the block, is all too vague for me. So it was the wrong thing for him to do, and it was equally the wrong thing for you to do. And courts don't have time to help wrongdoers. And I assume you haven't had anything to do with him for a while.
No.
Great. Goodbye and good luck. Keep it that way. We're done here.
Court is adjourned.
Situation happened where I was in an accident and he couldn't understand that. There was not a me and him for a while, so this is it.
So after reading the complaint and the answer, I'd say that was a pretty even wash, because what he was claiming the value of his car was and what she was claiming the damages that he caused.
Car was worth between
$3,000 and $5,000 for a private party sale.
Right.
So I think you both
And
do the
she
wrong
was-
thing, and you can't be enriched for that.
both did the wrong thing.
Mm-hmm.
I didn't believe him at all. And I think that maybe she was a little tipsy when she was driving. She shouldn't have been driving anyway.
Driving without a license is a serious offense. that-
Yeah, and evidently she's done it before.
Yeah,
She gets tickets for driving without a license. Please.
Daycare owner Lakeisha Thomas is suing her former client, Kalisha Fry, for 1 month of daycare services, fraud, and breach of contract.
Court come to order.
Have a seat, please.
Hello, Judge.
Hello.
Case number 1116, Thomas versus Fryer.
Thank you.
You're welcome.
Miss Thomas, how long have you had a daycare center?
Since 2006.
And are you licensed?
I am licensed right from the start.
In what state?
Georgia.
How many children are you allowed to have in your daycare facility?
I'm allowed to have 6 in the daytime and 6 at nighttime.
Give me the hours that you watch children during the day.
From 5:30 to
In the morning.
5:30 a.m. to 5:30 p.m. It's 12 hours there, but it's 9 hours per child.
What does that mean?
And I can care for children for 9 hours, up to 9 hours, because of my family home daycare.
How many children can you have full-time as children in the home at one time?
At one time, 6 children.
During the day?
During the day. Yes, ma'am.
And when you say 6 at night, does that mean overnight, that they stay overnight, or part of the night?
That means, I guess, part of the night.
You don't know?
3 p.m.
Do you usually have children who stay the night?
No, ma'am.
So it's just really during the day that you take care of up to 6 children a day?
Yes, ma'am. My night hours are 3 p.m. to 11 p.m. or 4 p.m. to 12 a.m.
Okay. And you're paid additionally for that?
Yes, ma'am.
Do you usually have 6 children in your program?
Yes, ma'am.
Since 2006, would you estimate that most of the time you have maximum capacity children?
Yes, ma'am.
Ms. Fryer, the first time that you went to the plaintiff's home to look for a place for your 2 children, did you go during the day?
Yes, ma'am.
And how many children were there?
I'll say 4 or 5.
Okay. This is about money that you claim is owed to you for taking care of the defendant's children.
Correct.
And falsely disputing a charge. So I'm going to start with Ms. Fryer. How old are your children?
Now they're 1 and 5.
Now, you are originally from Texas?
Yes, ma'am.
You were moving to Georgia?
Yes, ma'am.
Month, day, and year?
I moved in September. September, I really don't know the date. It was like September 10th of 2020. I contacted her a month before, 2 months, almost 3 months, June 2020.
To tell her that you were moving and that you were interested in her daycare?
Yes, ma'am.
Okay. And did you go to see it before you enrolled your children?
Yes, ma'am. I actually went to see her, and I told her that I got it.
In what month? Was that in September?
That was when I went to go. Oh, it was September. Yes, ma'am.
Do you remember what date in September?
I'll say like the.
Do you know when in September?
I do. Around the 10th through the 12th.
When did your children start in her daycare?
I'll say it was after the 14th.
Yeah, the last week of September.
Give me the date.
Oh, I think it was the 28th.
Yep, 28th.
That's when they started?
Yes, ma'am.
Both full-time?
Yes, ma'am. It was actually past full-time.
Okay, so full-time.
Yes, ma'am.
And then you agreed with her, according to what I read, about how much she would be paid every 2 weeks to take care of the children.
Yes, ma'am.
And what was she supposed to be paid every 2 weeks to take care of the children?
$352.
Bi-weekly?
Bi-weekly.
Did you sign a contract?
Yes, ma'am.
You have a copy of the contract? May I see it, please? What is this loan and or daycare tuition repayment form?
My loan and daycare tuition form is for parents who cannot pay me on my stated Monday tuition payday, or if a personal loan is loaned to anyone. And the daycare tuition repayment form is because Ms. Fryer couldn't make Monday payments. My tuition is due on Monday.
But she says you made an arrangement with her to pay $352 biweekly. Was that your agreement with her?
That was my agreement with her up until January.
Just a second.
Sorry.
Was that your agreement with her?
Yes, ma'am.
Okay. And you started September 28th?
Yes.
And did you make biweekly payments through October 28th?
No, ma'am. I actually, October 23rd was the last time she seen my children because my...
Just a second. You were actually there for 4 weeks?
Yeah, no.
Yeah, 4 weeks.
I was there actually for 4
Your children were there for 4 weeks?
Not too long.
Mm-hmm. Just a second. We were actually physically in the location for 4 weeks?
Yes, ma'am.
So if your children were there for 4 weeks, you should have paid her $704. Did you pay her the $704?
Yes, ma'am. I paid her that amount. I paid bi-weekly.
What I want to know is, did you pay her $704?
Yes, ma'am.
And those payments, you did not have reversed to the bank or anything else?
No, ma'am.
You actually paid her $704?
Yeah, we did it through Cash App.
How much did you receive from the defendant between September 28th and October 23rd? That's a question.
Daycare owner Lakeisha Thomas claims her former client, Kalisha Fryer, is responsible for 1 month of daycare services after Kalisha disputed the charges.
Look at your papers, and
Okay.
I want to know how much you were paid for those 4 weeks. It should have been $704.
The registration fee is $65
Just a
per
second.
child.
No, Joe.
Yes, ma'am.
Understand something. I asked you a question. I said, how much were you paid by her between 9/28 and 10/23? The biweekly should have been $704.
That's correct.
How much did you receive from her in total?
$704 plus $130.
Okay, so you received what you started to say was a registration fee plus the $704. Were any of those charges reversed by a bank?
Those charges were 2 weeks.
That's either yes or no?
Yes, ma'am.
Which 2 weeks?
The week of October 24th, that week.
You mean the
2
week
weeks
that was-
prior to that?
So she reversed one payment of $352. Is that what you're saying to me?
She reversed 2 payments. Ms. Fryer stated her children were with me until October 23rd. That's not true. They came another week in October, and they came 3 weeks in November. So
Just
I don't know
you know
where.
they were there, actually physically there.
In my presence, yes, ma'am.
Really? May I see your records?
You can, yes, ma'am. Here's November, here's October. I have video footage of the children with me, and I have pictures
I
of
would
the
love
children
to
with
see-
me.
I would
After
love,
October
just a
23rd.
second, I would love to see it.
Absolutely.
Now, before I look at that, and it's not that I wouldn't like to look at it, which I probably will, you want to rethink of when your children were last there? They weren't there.
October 23rd of 2020.
I text me.
She says that they were there. That's Arthur and Keyshawn?
Their name's Arthur and Cashton.
Arthur and Cashton. Okay. Well, I only have October through October 30th, the 26th through the 30th. That's 1 week. Oh, there's November. I have it through, well, you have it through November 19th. So you have video showing me the children there after October 23rd.
Yes, ma'am.
I'd like to see it.
Yes, ma'am. It's labeled Judy Justice. If you want to press that one, and she can see the timestamp. Yes, sir.
This one right here, Judge. The one top right.
Well, I have one photo here on October 29th.
I mean, she could have got the photo anywhere.
And timestamp?
Just a second. No, it says October 29th, 10:25 a.m.
Okay, she could have.
Are these your
screenshotted.
children?
I can't see.
Oh, wow.
Yeah.
Yeah, okay, good. That-
That's a video, Your Honor.
What?
That if you go back,
Yeah.
this is a video. It's a screen recording of a.
Would you do me a favor? See if you can negotiate that for me.
Okay. You can see here. It says home, November 10th, 9:58 a.m.
My birthday.
It's just that's.
Got it.
Yeah,
That's
she
no-
screen recorded a security footage or something.
You
But
mean
it's
the
timestamped.
security
It's-
footage from her house?
Yeah, it's timestamped at November 10th, 2020 at 9:58 a.m.
Got it. Do you want to see the video?
I mean, she could have found video and screen recorded it. It's, I could easily screen record this right now.
So I want you to prove to me that you were not in Georgia after September 23rd.
Do you want me to go through my phone?
I don't care how you prove it to me. I want you to look in your phone and show me that you were not in Georgia after September 23rd.
October. Can I show you text messages from our last conversation, please?
It's October 23rd.
October 23rd.
Oh, this is a different phone. This is a different phone. I got a whole nother phone.
Everybody who can't find something finds a whole other phone. They get a whole other phone.
Yeah.
Something happens to their
got
phone.
that from someone.
Who's that?
My husband.
Stand up.
How you doing? Judy?
Stand up. Did you move with your wife from Texas to Georgia?
No, ma'am, I did not.
Where were you?
In Texas,
What were you doing there?
working.
And why did your wife go to Georgia?
Well, she wasn't my wife at the time. I met her during this process.
What date did you meet her?
I would probably say September 18th or so.
Where did you meet her?
How did I meet her? On a website.
But she was in Georgia at that time.
No, ma'am, I was not in Georgia.
No, she was in Georgia.
Yes, ma'am.
She was in Georgia when you met her on a website.
Yes.
Don't touch him. So you met her on a website.
Yes.
When did you marry?
We're in that process at this time now. Getting
So you're not married.
right, but I mean.
Is that so?
I'm
The
saying
answer is you're not married. Either
we-
you're married or you're not married. People know when they're married or when they're not married.
You understand? Like I'm saying, we're in that process right now as far as we are going to court for it, because I have to get some things off of in order to
Sir,
get married.
either you're married or you're not married. You are currently not married.
Currently, right, which I answered.
Either you're married or you're not married.
I mean, you asked me the question. I gave you the answer to begin with.
Then just answer the question.
I've given
She
you
said,
that.
"This is my husband."
Right.
It is.
No, it's not your husband.
I mean, but common law marriage.
No, there's
common law marriage
no,
would make
it doesn't
it make
exist.
sense.
It doesn't exist anymore.
Oh well, according to the staff of police in Texas, it does exist in Texas.
Okay. The only time common law may exist in some jurisdictions, because it's outlawed in most, is when you live open and notoriously with someone for a period of either 10 or 20 years or more.
Oh.
Then you can be considered in some jurisdictions, maybe in some remote state, but most states have outlawed common law marriage.
Oh well, I'm just giving you the information that was given to us.
Just give me information. So you're not married. You met in September of 2020.
Right.
She was in Georgia. You were in Texas.
Yes, I was.
Okay. Were you working in Texas?
Yes, I work in Texas.
Okay. What were you doing? What kind of work?
I do music. I'm an entrepreneur in the music business.
Had you known her before?
No, ma'am, I did not.
So you met her online?
That's what I'll give you the information of earlier.
Okay. When was the first time you met her in person?
Probably February.
So you met her in September, October, November, December. You didn't see her Christmas time?
No.
What about Thanksgiving? Did you see her on Thanksgiving?
I don't celebrate holidays, no.
When you were communicating with her, was she in Georgia?
Yes, ma'am.
Did you know where she was living in Georgia?
No, ma'am. I did not know exactly where she was living.
Did you know if she was working?
Yes, she was working at that time.
During Thanksgiving or Christmas, did she ever tell you that she stopped working?
Yes.
When did she tell you she stopped working?
October somewhere. Whenever the kids that had symptoms of COVID, they had to be released from go through the 14 days of COVID, and she had to do an extra 14 days. So that made 4 weeks that she had to sit for COVID, and she eventually lost her job.
Do you remember what day that was?
Around October 23rd, around that, or 25th, somewhere around there.
Okay.
Daycare owner Lakeisha Thomas has accused her former client, Kalisha Fryer, of owing for 1 month of daycare services. Kalisha disputed the charges with her bank, claiming her boys did not attend the daycare that month.
Can you show the witness, please, the video of the children from November 10th? Was there ever a time that the defendant's children were out sick?
No.
Did she ever tell you that they were out sick?
No, ma'am.
Okay. I assume that if your children were sick and you were out with them for a month, that you took them to see some sort of pediatrician or urgent care. Can I see proof of that?
Actually, I went to a hospital, and we didn't have Medicaid or nothing like that.
Well, they would give you a...
No, they just gave us they didn't have COVID.
What's the name of the emergency room that you went to?
I don't know, Honor. I just barely moved to Georgia. It's like South Georgia Hospital.
Tell me on what date you reversed the charges on checks that you were given to her.
I reversed the charges?
Yeah, did you ever reverse charges?
I actually talked to Keisha and let her know that what was going on before this time, and she was cool. She was like, all right, you're a cool person, la, la, la. And there's no...
I just asked you a simple question. I said, did there come a time when you reversed charges on a bank for money that you had paid her?
I contacted my bank.
That's what I'm asking you.
Oh, I let them know.
On what date did you contact your bank to tell them to reverse the charges on a check?
January 2021.
January what?
7th, I guess.
28th.
No, 7th.
Well, if according to you, the last time that your children were there was on October 23rd, why would you be reversing charges in January?
Because she was still getting my money from me. My kids wasn't there the 4 weeks, so why should I pay her?
What I'm asking you is, you had to have paid her. Was she on an automatic payment?
Yeah.
So what you did was you told the bank to stop making automatic payments. But you didn't stop in November. You stopped the end of January. You didn't stop in November. According to you, you stopped in January.
Because she said she was going to stop them.
Okay, now I'll see the email.
Text message. Yeah. Gotcha. There we go.
On November 11th, at 5:19 in the morning, hey, we're going to be there around 9. GM, okay, we'll be here. At 5:35 a.m., you respond, we just woke up. No worries, we'll be here. I don't know where Cash Cup is, and she didn't either. If you find it, let me know. And then on November 20th, they're not coming.
I don't recall none of these messages.
You don't?
No.
You have a bad memory.
Yeah.
Bad memory and nasty. Bad and nasty.
November 20th.
Bad and nasty. Sit.
Would you?
Sit. You sit down.
I mean, it's the way that you
Sit down.
Stand up.
So what you want me to think about looking at this is that the plaintiff, who's been in business since 2006, and as kids, you said she had 4 or 5 when you went there to visit, that she somehow got somebody to change the digitalized date stamp on a video, and she somehow created text messages with you going back, oh my God, for October 7th. That is a child that belongs to you?
That's my child.
Right. All these text messages go all the way back to October 1st from the same number. Do you understand?
I can stand.
All the way.
You said
Sit.
You said stand.
Don't.
Which one you want me to do?
I didn't ask you to stand. I said, do you understand?
Oh, do I understand?
Do you understand? They go all the way up to November the 20th. And she made all that up.
It's 2020.
There are some people that just will never get it, and they will go through life never getting it. And the sad part of it is people that go through life who never get it are going to teach that to their children. Judgment for the plaintiff in the amount of $1,900. We're finished.
Court is adjourned.
Thank you.
She was wrong.
I'm glad justice was served.
She did Photoshop.
People told me that folks would come up with whatever they want to come up with to get out of it, so.
You can do anything to an iPhone.
I don't even know, and I don't even care.
I ain't going through this again.
I'm glad it's over.
See, I told you there's some upside of learning all the technical timestamps and location stamps and things like that. The plaintiff really had it all together, and she had her evidence, and it was very clear from the timestamp on the video and the photo that it was at her home. It had a location on a map that you could see and a specific time, and it just shows that technology can be useful sometimes.
Yes. I'm sure it would be very helpful if someone could teach me how to use those things. Until that time comes, I'm going to have somebody sitting right over there who can get it for me. I don't know, I really tried, but I find it very difficult to master. I've just learned how to send an email, which for me is a giant leap forward into this century.
I'm doing my best. We have time.
Thank you.
Case number 1122, Clark versus Albro. All parties, please step forward.
Rapper Kyrie Clark is suing video director Rashad Albro for the production costs of a music video.
Mr. Albro, you look angry before we start. Put your hands down. Thank you. You may get there, but I haven't started yet. Now, Mr. Clark, it is your claim that the defendant, at your request, made a music video for you, that you paid him, that he, A, didn't deliver it on time, and B, did a less than professional job, which required you to hire someone else to either do it again or to fix it. In any event, what you are requesting is the money that you paid to Mr. Albro and the cost of redoing the video Mr. Albro says that you were initially satisfied with the video, which he acknowledges that he delivered late. He said that because of personal issues, and he had some, he was delayed by a couple of weeks in getting you the video, but you were satisfied with it and subsequently called him and told him that there were things that were deficient. That the case?
No, that's not the case.
Rapper Kyrie Clark claims video director Rashad Albro owes for the production costs of a music video. Kyrie also claims Rashad stole his video concept and used it with a different artist.
The part that you are questioning is the part where he says you told him you were satisfied?
I told him that I was satisfied.
So what is it that I was mistaken in suggesting that your position was?
Okay, so I'm going to explain, Your Honor.
No, don't explain. Just tell me the one thing that is not correct.
The main issue is that he basically took my original idea that I came up with, and he made sure that his cameraman panned me a certain position so that you couldn't see anything aside from, it goes from my head all the way down to my knees. So you couldn't see any of my props with the original idea that I came up with, which I have documentation as well. And he made sure that it wasn't in my video, and he put it in his client's videos.
Mr. Clark, did you trademark or register an idea that you had?
No, I do not, but it is in my notes that I told him the idea of what I wanted.
It doesn't matter.
Okay.
Is that the only thing that you have issue with, that he used some of your ideas in a second video that he did that had nothing to do with you?
Yes, because he made sure that he didn't put it in my video. I told him the place that we were going to shoot and the concept as well. What
I'm telling you is, unless you do something to trademark an idea, it is really not intellectual property.
Okay.
See, I don't understand, making music videos. What I understand is making parties. So I'm going to bring it to something I understand, and then we're going to get to what is actionable. I have a wonderful guy, and he's been doing parties for me forever. He has outrageous arrangements, food and cakes and cookies, and everything is fulsome and wonderful. And it's really not only a delight to the palate, but it's a delight to see.
Mm-hmm.
Right? Mm-hmm. And there was somebody else that I knew, was a friend of the family, who said, gee, I'd really love to come to see one of the parties set up because maybe I can get an idea or two from what he's doing so that it would help me in my career. I said, you want to come? Come. You can't, because you've envisioned something and you put it out there, you don't hold a right to it. So what you're saying to me is you had certain ideas about how this was going to be portrayed, this music video, you had certain props that were there, and he can say, gee, that was a terrific idea to have a pumpkin, to have a dancing strawberry, to have whatever it was.
I'm sorry, Your Honor. I really hate to interrupt you, but honestly, your cake story, it is not my story, okay? When I came up with this original idea, let me tell you something. I used to actually live in LA, okay? And when I lived in LA, I was in the street. I got my head sliced open while I sleep on the beach. I got my head cracked by security when I sleep at a restaurant patio. Everything that I went through, that is why I came up with that idea. And that's why I put everything that I just told you about, I put that in my track. That track is 5 minutes long.
Okay.
You feel me?
What I'm telling you
Go
is
ahead.
that your complaint says, I'm suing the defendant, Rashid Albro, in the amount of $1,302.02 for a refund on the video shoot and the cost to fix his work. That's what your complaint says, sir. That's what I'm hearing. Do you understand?
What I put down is that I'm suing for the cost of the video. I'm suing for the $50 for.
Kevin.
Okay.
I just want you to read what I have that you're suing for and what the defendant has been served with. And that, Mr. Clark, is what you are bound to today. Mm-hmm. Kevin, I'll take that back now.
I didn't read it, but okay.
Well, that's, Mr. Clark, Mr. Clark, I'm going to take it back now, Kevin.
You got it back.
Mr. Clark, when you file a complaint, a defendant in any court action is then put on notice of what you are suing them for, what they have to defend. He is put on notice now of what you're suing for. And I'm telling you, today, the only thing that I'm hearing is what you put in your complaint.
Which I didn't get to read, by the way.
Well,
so I don't know what it says. I don't know what it says. I don't know what the complaint says.
Mr. Clark, that would be your fault.
How is it my fault? Because it should be in there. But I guess what? I didn't get to read it, so I don't know if it's in there or not. You told me to read it. You want me to read that whole paper in 10 seconds? And then you ask for it back?
No, that's what you signed.
Oh, well, didn't you give it to me to read? Right?
But you signed it, sir.
But I read it earlier, and earlier is not what you're saying that's on there.
Would you show it
to
him
me
again?
All you're saying is that I'm suing him for just the video. Oh, go ahead.
Quiet.
Go ahead. Okay.
Don't sound foolish.
Oh,
if you
I'm not
signed
sounding foolish. Who's the real one sounding foolish? You talking about I read it. You wanted me to read it.
Mr. Clark, either you read this before you signed it.
I did read it, so why did you hand it to me if you wanted me to read it again?
Well, I don't like your attitude, Mr.
I don't
Clark.
care.
So, Mr. Clark, I don't like your attitude.
Okay.
I think your attitude is disrespectful.
And you're not making any sense. You're telling me to read stuff and read stuff in 10 seconds. What sense does that make? You want me to read stuff in 10 seconds?
So this is what I'm going to do.
Go, do what you do.
I am dismissing your case without
Yeah, because I know
prejudice.
because you're a hater and you
take
really
it
are
back
not
to the
intelligent
court
at all.
In which you originally
Guess what,
filed
baby girl?
it.
I really don't
we
care.
are done here.
Court is adjourned.
He messed me over because he sold the original idea that I came up with everything that I've been through in my life.
I'm not sure. Like after the shoot.
Sold my original idea and made sure they wasn't in my video. Then I paid him a backhand payment super early when I really didn't have to.
He was happy with everything. After he received the video, he was happy with it.
Business associates, I've never met him a day in my life. And he said he was a videographer. I seen him on Facebook and I liked his work.
That I didn't show the props that he wanted shown, and that I didn't deliver on time.
But guess what? I did my part. I did my part. I did my part. The universe know all that. I did my part.
After all the argument and text message, he tried to book me again. And I told him we wasn't doing that. So that's probably what he mad about. That's probably why we're here today.
Sarah, you just saw an example of courtroom television style, because sadly, I don't have the ability to hold somebody in contempt, which I would have done.
We should look into that.
Yeah, which I have done very sparingly over the course of my whole career. But I gave this litigant every opportunity. Back up, let's try again. This is what your case is about. And once you see that someone is an obstructionist, there's only one order in a courtroom, and that order has to come from somebody. If it's not from a judge, it's going to come from a litigant. And once you let a litigant take control of the process, then the process gets all screwed up. Anyway, good luck to him in another forum.